Hi, my name is Nilo Sanchez of Sanchez Associates. Our office is located at 1006 North Armenia Avenue. I am here today to talk to you a little bit about parenting plans. In Florida, when you have a minor child, which is defined as a child under the age of 18 years of age, the courts require us to have a parenting plan. The parenting plan is a document that is broken up into several different sections. First, we start off with the type of parental responsibility that you will have with your child, for your child. Normally, we have what's called shared parental responsibility. Shared parental responsibility means that both parties have an equal say with respect to their child's life. When it comes to major decisions affecting the child, it's envisioned under shared parental responsibility that these decisions will be made jointly and by agreement between both parties. However, if there is a major decision affecting a child, such as medical or education, and the parties are unable to agree, after attempting to agree by going to mediation, the parties can seek relief from the court by asking the court to appoint them with the particular authority over that decision. And that's what we call ultimate decision-making authority. It's not something that happens very often. However, there are occasions where there just might be a disagreement over a significant matter and neither party is willing to capitulate to the other parent, and in which case you have to seek relief from the court to be appointed with the decision-making authority. After parental responsibility, we get into timeshare. There are three different types of timeshare that you see in the parenting plan in general. We have the ongoing timesharing schedule, we have holiday schedule, and we have the summer schedule. And I'll talk to you a little bit about each of them. The ongoing schedule is what your timeshare is to the children or to the child on a daily basis. If you were to have, let's say, a 50-50 timeshare schedule, which is not necessarily something that the court will guarantee to grant the parties. However, it is a little bit more prevalent, at least here in Hillsborough County at this point in time. What a 50-50 timeshare schedule, it could be 1 week one parent, 1 week the other parent, and it could be any particular day as to the trade-off day. It could either be a Monday or Friday or any particular day. We could have a 2-2-3, which is Monday, Tuesday one parent, Wednesday, Thursday the other parent, and then alternating weekends. After you conclude the ongoing timesharing schedule, the next type of timesharing is holidays. And there are several different holidays that are delineated in the parenting plan. And the idea behind it is that we divide them on an odd and even basis so that on certain years, one parent will have certain holidays, and then on the other year, the other parent will have the holidays. For example, you may have Christmas Eve one year, and then the following year, the other parent has Christmas Eve. Same thing could apply to spring break. Again, these are things that by agreement, the parties can attempt to come up with the schedule, and if they're able to do so, the courts generally are going to accept it. If you're not able to agree, then the courts will basically enter an order granting a particular holiday timeshare schedule. But in general, it does follow an alternating type of basis. The next type of timesharing is summer. In the summer, this is an opportunity when the kids are out of school to be able to take a trip and have a little bit more downtime. And again, by agreement, the parties can come up with a multitude of different types of schedules. Usually what you see is at least a 2-week timeshare schedule for the parties, and it could either be consecutive or non-consecutive, meaning that you could take 2 weeks together or 2 weeks that could be interrupted. And the idea behind that is to take a trip. And the rest of the summer, you follow the regular schedule. So the parenting plans are intended to be there when the parties are not able to agree. We often say that you can get your parenting plan and you can put it in the drawer of your desk and not have to follow it if the parties are able to agree. However, if they're not able to agree, then the parenting plan is intended to be followed, and the court has jurisdiction and authority to enforce it. The court also has jurisdiction to modify it as well, and that's dependent upon what we call a substantial change in circumstances. In general, what we try to tell clients is to try to come up with an agreement to resolve the parenting plan, because this is your opportunity to co-parent with the other parent, and your child is the one that benefits the most between the parties being able to agree. We typically recommend that you put a lot of specificity into the plan so that you can avoid particular situations where maybe there's a gap and there's a question. Again, you can deviate from it as long as you are in mutual agreement. If you have any questions about parenting plans and would like to schedule a consultation with us, please do not hesitate to give us a call. Again, my name is Nilo Sanchez, and I am with the law offices of Sanchez and Associates. Thank you and have a nice day.